If you're grappling with disability concerns or navigating those really complex leave issues, maybe tackling tricky wage challenges in your workplace, believe me, you are definitely not alone.
Oh, absolutely. It's such a high-stakes game for any organization, isn't it? And just one misstep in those areas, well, it can lead to some incredibly expensive consequences.
It really can. We're talking about impacts that go straight to the bottom line.
It's true. The financial side can be staggering. It hits your operational budget, your profitability. So understanding all these nuances isn't just about, ticking a compliance box.
No, it's fundamental. It's about protecting the business itself.
Precisely.
And that's exactly why we wanted to do this deep dive today. We were both at this really unique and incredibly insightful session, a high-stakes Workplace Jeopardy game.
That's right. It was quite something. Imagine being right there with us, playing along as these complex challenges got broken down. It made the whole legal landscape feel, well, genuinely accessible.
And maybe even a little bit fun, surprisingly enough.
Huh. Yeah. Lou Lessig has a way of doing that. He was our expert guide for that session, the employment law translator, as he's known.
He's a partner with Brown & Connery, LLP, right?
Yep.
Really respected litigator, national speaker.
Yep, super lawyer since 2012, Delaware Valley HR Consultant of the Year. The list goes on. He really knows his stuff.
What struck me being in that room was how comfortable he is. I mean, one minute he's talking about saving clients millions in court, which he has just in the last few years. And the next, he's on stage making these dense legal ideas crystal clear for everyone. That skill, making it accessible, it's just fantastic.
It really is. So our mission today, really, is to unpack the critical insights from that Workplace Jeopardy session. We want to focus on those actionable strategies for you, the employers.
Right, covering things like disability, leave, wages, what you can actually do.
Exactly. Think of this as your shortcut. You get the surprising facts, the practical takeaways from those real-world scenarios Lou used, all geared towards protecting your organization's budget.
Okay, let's dive in. Let's hit that Workplace Jeopardy board. First category up was leave challenges, mastering the FMLA and policy application. And the power of documentation, wow, that came up immediately.
It absolutely did. One of the first questions Lou posed, remember, it was about that hospital cook fired after FMLA leave.
Yeah, your first instinct is retaliation.
Right. But the key, and Lou really hammered this home, was the existing, well-documented misconduct. Things totally unrelated to the leave, like refusing tasks, making French toast, I think.
Or getting onion rings, yeah. So for an employer listening, what's the real takeaway? It's more than just document everything, right? What was Lou's deeper point about those pre-existing issues?
It's how that meticulous pre-existing documentation acts almost like a firewall. It breaks that causal link someone might try to draw to the FMLA leave.
Ah, okay. It shifts the focus.
Completely. It puts the focus squarely on legitimate performance or conduct problems that were there before the leave even started. So the big lesson is, get your documentation clear, consistent, and contemporaneous, and keep it separate from leave discussions.
Do it before any protected activity kicks off. That makes a ton of sense.
It can make all the difference.
Okay, so from the paper trail, Lou then highlighted something he called the weight of temporal proximity. What was the story there in the leave context?
Well, it's all about timing. How close together are the protected activity, like taking FMLA leave, and the adverse action, like a demotion or transfer?
Right.
He used that case where someone got moved to a less performing store right after their leave, and that close timing, just the proximity itself, was enough for the case to move forward.
Wow. That's a powerful reminder. Makes you think how easily an innocent action could look bad if the timing's off. So the practical advice from Lou.
Be extremely careful. If you're taking adverse action soon after protected leave, you need a rock-solid, clearly non-retaliatory reason. And it needs to be obvious.
Documented, presumably?
Absolutely. Documented and clear.
Okay. Still in leave challenges, the Jeopardy game also touched on deviating from neutral policies, specifically around religious accommodation, Title VII. Lou used that Southwest Airlines example, the employee disciplined over social media posts about her Christian beliefs.
Yeah, that was a compelling one. The core idea is that sometimes your standard neutral policies might need adjusting for someone's religious beliefs.
So you have to deviate.
You might have to, yes. Unless, and this is the key phrase Lou emphasized, unless it causes an undue hardship.
And undue hardship means more than just inconvenience.
Much more. It means a significant difficulty or expense for the business. So the takeaway isn't just having a policy, it's being flexible. You have to assess each request individually.
You can't just say, nope, policy says no.
Not if the reason is religious accommodation, unless you can prove that genuine undue hardship. It's about the actual impact, not just sticking rigidly to the rulebook.
Got it. Okay, let's switch gears. Big category. Disability actions navigating accommodation and qualified individuals. This part of the Jeopardy session was packed.
It really was. One case Lou highlighted showed the real cost of delay. The failure to accommodate. Remember the school district and the veteran?
Oh, right. The service animal request. They took 6 months to respond.
6 months. And Lou's point was, even for requests that don't seem like a huge deal, that kind of delay can create a viable claim for failure to accommodate.
So the message was crystal clear. Respond promptly. Engaging in that interactive process quickly isn't optional.
It's absolutely non-negotiable. Don't let requests get, as Lou likes to say, lost in the sauce. Someone needs to own that process.
He also clarified the acceptability of indefinite leave.
Mm-hmm.
That case with the pediatric surgeon asking for indefinite leave for COVID and then some undefined new role.
Yes, and that case really underlined why indefinite leave generally isn't considered a reasonable accommodation under the ADA.
Why is that?
Because accommodations need to be, well, reasonable and defined.
Yeah.
Open-ended, I don't know when I'll be back requests. Employers typically aren't legally required to grant those. It brought some much-needed clarity there.
That's helpful. Then there was the point about defining qualified individual with job descriptions. Seems basic, but Lou showed why it's vital. The mechanic at the mine.
Right, who couldn't meet the physical demands after an injury. And the lesson was how crucial those specific physical requirements for a particular job title are in the job description.
Things often overlooked in generic descriptions.
Exactly. Without that specificity, it's tough for the employer to argue the person isn't qualified because they can't perform essential functions. You haven't defined them clearly.
So the practical advice, dust off those job descriptions. Make sure they accurately list the essential physical requirements. They're not just HR paperwork. They're a legal defense.
Absolutely. And finally, under disability, Lou gave us a reminder about understanding episodic impairments.
Right. Conditions that aren't constant, like panic attacks.
Precisely. He stressed that an episodic impairment can still be a valid impairment under the ADA if it significantly limits a major life activity when it's active.
So employers need a flexible approach. It's not just about permanent, visible disabilities.
Exactly. The ADA's reach is broader than some might think.
Okay, let's tackle a category that definitely keeps employers on their toes. Retaliatory focus, identifying and defending against claims. Lou's litigation background really came through here in the Jeopardy game.
It sure did. And one key distinction he made was about beyond belief, the causal connection. Just because an employee believes they were retaliated against, well, that's not enough.
Belief isn't proof?
Not legally. There has to be a demonstrable causal connection between the adverse action and their protected activity. He used that example of the police investigator who felt put upon.
But couldn't connect the dots legally.
Right. She lacked that necessary link for a viable claim. So the lesson for employers, you need objective evidence showing a lack of connection. Opinions just don't cut it in court.
Makes sense. He also talked about the danger of conclusory assertions.
Yeah, like the accountant who just claimed discrimination without any real facts to back it up.
Mm-hmm.
Lou explained how those kinds of bald assertions without substance get dismissed.
Courts need facts, not just feelings or general complaints.
Exactly. If you're defending a claim, push for that factual basis.
Now, one point that really gives pause was the importance of who made the call. That University Associate General Counsel case had a panic attack, requested accommodation.
And was then fired by the supervisor who actually witnessed the attack and denied the accommodation. Yeah. Lou explained how having the same person involved in both the protected activity request and the negative action creates a very strong inference of retaliation. It makes it incredibly hard to argue they weren't connected.
So the warning for employers is significant. Be extremely careful when the decision maker for firing or discipline also knows about the protected activity or accommodation request.
You have to be meticulous. Ensure the decision is based on legitimate, non-retaliatory reasons, and the rationale is absolutely airtight. Maybe even involve different people in the decisions.
Good point. But Lou also offered a defensive tool, the honest belief defense.
Right. This is a practical one. If an employer genuinely believed there was a legitimate issue, say, misconduct, and took action based on that belief.
Even if the belief turns out to be mistaken later.
Even then, it can be a viable defense against a retaliation claim. It shows you weren't acting out of retaliatory animus, but based on the information you had, in good faith.
So again, it comes back to documenting the basis for your actions. Show why you believed what you believed at the time.
Precisely. That paper trail demonstrating good faith is crucial.
Okay, shifting to another really potent category from Jeopardy, exploring hostility proving and preventing harassment. This area is definitely fraught with peril. Lou's insights were really eye-opening.
They were. He talked about breaking the chain. Independent investigations. How having an investigation done by impartial people.
People not connected to the employee or their supervisors.
Exactly. How that can break the causal connection of animus. He used that IT employee example whose claims were dismissed partly because of those unbiased third-party investigations.
So the clear takeaway: invest in robust, impartial, internal investigations. Use trained people separate from the conflict. That objectivity really matters to courts.
Hugely. But then Lou talked about something more subtle. Subtle retaliation. Shunning and exclusion.
This was fascinating. Acts like not inviting someone to a meeting or generally shunning them.
Yeah, things that might seem minor, but Lou pointed out that could be clear examples of costly retaliation claims. He brought up that WNBA player case.
Where she wasn't invited to the White House and they didn't show her daughter on camera after her pregnancy. Potentially retaliatory.
It's a stark warning. Retaliation isn't just firing someone. It can be these subtle acts of exclusion, creating a negative environment after someone engaged in protected activity.
Perception matters, definitely. And related to that, Lou stressed looking at the totality of the circumstances for discrimination.
Yes. Don't look at incidents in isolation. He used that powerful example of the black manufacturing worker. Racial slurs, physical harassment.
The court looked at the whole pattern, the cumulative effect.
Exactly. Even if individual acts seem small on their own, together they can create a hostile work environment. Employers need to connect the dots, see the bigger picture, because you can bet a plaintiff's lawyer and the court will.
Wise advice. Okay, final category from Workplace Jeopardy, the catch-all. But there is more miscellaneous but mighty insights, some real surprises here.
Definitely. Like the retiree exception under the ADA, Lou pointed out a Supreme Court ruling that basically says retirees generally aren't protected by the ADA.
Because they lack control over employment conditions anymore?
Essentially, yes. That's a crucial nuance, especially for anyone dealing with benefits for former employees.
Good to know. Then there was the HR professionals and FLSA claims scenario.
Right, the attorney turned HR chief people officer who pointed at a wage violation and got fired. Lou explained that for HR folks to get FLSA retaliation protection.
They need to step outside their normal advisory role.
Kind of. They need to make it clear they're acting against the company's potentially illegal practice, maybe on behalf of themselves or others, not just giving routine advice. It's a fine line.
An important one, though, for HR pros and employers to understand.
For sure. Lou also clarified reverse discrimination claims. The big news there.
That plaintiffs no longer need to show those specific background circumstances, suggesting the employer discriminates against the majority.
Exactly. Referencing the Ames case and the Supreme Court, it just reinforces the principle. Equal treatment for everyone, regardless of race, gender, etc. No special hurdles for reverse discrimination plaintiffs anymore.
Levels the playing field.
It does. And the final Jeopardy topic Lou threw at us. Social media madness. Defamation by former employees.
Ah, yes. The takeaway being
that employers aren't helpless if a former employee starts posting defamatory things online. If you can make a valid defamation claim proving false statements made to a third party that harm reputation leaves, you might get a temporary restraining order, a TRO, or other legal relief.
So it's not a complete free-for-all online after someone leaves. There can be consequences.
There can be. Yeah. Looking back at all these Jeopardy categories and answers, the way Lou presented them, the big theme that just kept coming up was how proactive, diligent, well-informed HR practices are just the best defense, period, against all this potential workplace jeopardy.
Absolutely. And Lou didn't just highlight the problems. He gave us those really concrete next steps, actionable recommendations right from the employment law translator. We should probably recap those.
Good idea. First, he said, review your existing procedures, make sure you're meeting timeline requirements, don't let things lag.
Second, make sure your management consistently engages in the interactive process for accommodations. Make it the default, not an afterthought.
Third, and this is crucial, assign someone to actively monitor accommodation requests. Prevent them from getting lost in the sauce. That's a huge risk area.
Fourth, invest in keeping your investigators trained and updated. Laws change, best practices evolve, Outdated investigations are dangerous.
And fifth, regularly review internal decisions on these matters. Ensure managers are reporting things consistently and accurately. Consistency is vital.
Those are such practical takeaways. So as you, our listener, reflect on all this from our deep dive into Workplace Jeopardy, maybe ask yourself, how robust are your organization's internal controls and training?
Yeah, what are those next Jeopardy categories lurking out there in this constantly shifting legal landscape? Are your managers really equipped to play that game? And more importantly, to win it?